Section 28. The transaction file. If it isn't documented, can you prove it? Show me the file. 6 months after Emily and Carlos close on their Gilbert home, Sarah walks into her broker's office. Her broker has Emily's transaction pulled up on the computer. Remember the seller credit issue? Sarah nods. Of course. Her broker turns the screen toward her. Show me what happened. Sarah starts explaining. Okay, the seller originally agreed to one amount. Then we changed it after the appraisal, and I think Jason called me. Her broker stops her. Don't tell me from memory. Then comes the sentence every agent should be prepared to hear. Show me the file. Your memory is not a transaction record. Agents remember transactions very clearly while they're happening. 6 months later? Not so much. Was the seller credit 8,000 or 10,000? Did Jason call Tuesday or Wednesday? Was the amendment sent before or after the revised disclosure? Did Emily approve the change by text? Who notified Maria? Sarah may honestly believe she remembers, but regulators, brokers, attorneys, and clients generally prefer documents over recollections. That's why record keeping matters. Arizona has a 5-year requirement. Arizona law requires employing brokers to maintain specified transaction and employment records for at least 5 years from the date of the transaction or employment. That's important, but don't interpret that as, I personally keep a random folder on my laptop for 5 years. The brokerage maintains the official records according to its systems and policies. Sarah's responsibility is to make sure required transaction documentation reaches the brokerage file. If her brokerage requires documents to be uploaded within a certain time frame, she should follow that policy. Don't wait until someone complains. The real estate file is not the lender's file. Here's another important distinction. Jason's lender has federal record retention responsibilities under Regulation Z. Sarah's brokerage has Arizona real estate record-keeping responsibilities. Those aren't the same file. Sarah doesn't need to collect Jason's entire underwriting package. She doesn't need Carlos's tax returns. She doesn't need copies of every bank statement the lender reviewed. In fact, agents should be careful about unnecessarily collecting sensitive financial information. Sarah needs the records appropriate to her role in the real estate transaction. What should the file tell us? Let's look at Emily and Carlos's transaction. If Sarah's broker opens the file, can the broker determine what happened? The purchase contract should show the original agreement. The amendments should show the changed seller credit. The transaction records should establish the relevant closing terms. If Sarah communicated a material contract change to escrow, there should be appropriate evidence of that communication. If the parties signed another amendment, it should be there. If a compensation arrangement was changed, the applicable documentation should be there. The file should tell a coherent story. What about email? Sarah says, I emailed Maria the amendment. Great. Can you find the email? Electronic communication can become extremely important when a dispute concerns timing. Suppose the buyer says, Sarah never sent the amendment. Sarah produces an email showing the executed amendment was transmitted to escrow 3 weeks before closing. That matters. Now imagine Sarah says, I know I sent it, but there is no email, no upload, no transaction note, and Maria says she never received it. That's a much harder conversation. Text messages count too. Real estate agents conduct an enormous amount of business by text. Seller accepted, buyer agrees, lender needs extension, send the amendment, closing moved, seller credit approved. Those messages can contain material transaction information. Don't assume that because something happened on your personal phone, it has nothing to do with the brokerage file. Follow your brokerage's procedures for retaining transaction-related communications. The dangerous verbal conversation. Now imagine Jason calls Sarah. Sarah, the loan is having a problem. We may not close Friday. Sarah says, okay. Then she does nothing. Friday arrives. The transaction doesn't close. Emily says, why didn't you warn us? Sarah responds, Jason told me Thursday. Emily says, no, he didn't. Jason says, I think I called Sarah Wednesday. Now we have 3 memories and no documentation. A simple follow-up email could have helped. Jason, confirming our conversation today, you advised that financing may affect Friday's anticipated closing. Please keep us updated regarding the loan status. That isn't complicated. It's professional documentation. Document facts, not drama. Here's another broker tip. Your transaction notes should be factual, not buyer is completely crazy and doesn't understand anything. Instead, buyer questioned the seller credit amount shown on the closing disclosure. Referred buyer to lender and escrow for clarification. Executed amendment provided to escrow. If an ADRE investigator reads the file later, which note would you rather explained? Professional records should sound professional. Then the complaint arrives. Now imagine Emily actually files a complaint. Sarah's broker tells everyone, Preserve the transaction records. This is not the moment to clean up your text messages. Don't delete uncomfortable emails. Don't rewrite notes. Don't create documents and pretend they were written 6 months earlier. Don't backdate anything. Preserve the real record. If additional explanation is needed, the broker can determine the appropriate way to create a current memorandum or response that accurately identifies when it was prepared. What if the file is missing something? Suppose Sarah realizes she forgot to upload an amendment. What should she do? Tell the broker. Don't hide it. Don't manufacture evidence. The broker needs accurate information to evaluate what happened and determine the appropriate response. A missing document can be a problem. Dishonesty about the missing document can become a much larger problem. What would you do? Imagine you're Sarah. An ADRE investigator asks, when did you first learn that the buyer's closing disclosure showed the wrong seller credit? You remember talking about it, but you're unsure of the date. Would you guess? No. You would review the records, emails, texts, transaction notes, closing documents, then answer based on the available evidence and your broker's guidance. Regulatory responses are not the place for creative memory. Broker tip: build the file while the transaction is alive. The worst time to build a transaction file is after somebody asks for it. Upload executed documents promptly. Preserve important communications. Document significant decisions. Make sure amendments reach the appropriate parties. Keep the brokerage informed according to policy. Your goal is simple. If another competent broker opened your file tomorrow, could that broker understand what happened? If the answer is yes, you're doing something right. Sarah opens the file. Sarah searches the brokerage system. There's the amendment. There's the email to Maria. There's Jason's response. There's the corrected transaction information. There's Sarah's note documenting Emily's question. Her broker smiles. Good. Now we can answer the question. That's the value of a complete file, not because paperwork is exciting, because when memories disagree, documents speak. We have one section left in TR Idea Ahead. In our final lesson, we're bringing Emily, Carlos, Sarah, Jason, Maria, and the entire transaction back together. We are going to build the habits every Arizona agent should take from this course, from the first loan estimate to the final closing disclosure and beyond. Because the goal isn't to turn you into a mortgage compliance officer. The goal is to make you the kind of real estate professional who recognizes the problem before it becomes the complaint. Online discussion 1. Why is Sarah's memory alone not enough when a question arises 6 months after closing? Answer: memories can become incomplete or inaccurate over time. A well-maintained transaction file provides contemporaneous evidence of the parties' agreements, amendments, communications, and actions. Arizona broker record-keeping requirements and good risk management practices make accurate documentation especially important when a client, broker, regulator, or attorney later asks what occurred. 2. Does Sarah need to keep copies of every financial document Carlos provided to his mortgage lender? Answer: no. The lender's federal compliance file and the brokerage's real estate transaction file serve different purposes. Sarah should maintain the documents and communications required for the real estate transaction and follow brokerage policy without unnecessarily collecting sensitive financial information that belongs within the lending process. 3. Sarah discovers after receiving a complaint that an important amendment was never uploaded to the brokerage file. What should she do? Answer: Sarah should promptly tell her broker and provide truthful information about what occurred. She should not create, alter, or backdate records to make the file appear complete. The broker can then determine how the missing documentation affects the response and what additional steps are appropriate.